Hello, everybody. So the main difference between confidentiality and privileged communication exists as far as law is concerned. Confidentiality can be defined according to Remley and Herlihy 2020 as not only an ethical concept, but also a promise to the client that information received in session will not be revealed to anyone without the client's consent and that their privacy will be respected. While confidentiality is an ethical concept related to the release of information, privileged communication is a legal concept related to the release of that information. Privileged communication can be defined as the legal obligation to protect the client from having confidentiality broken in a court of law, ensuring privacy of communication with the counselor unless the client gives permission for disclosure. In order to enact that privilege, a professional status must be identified. So a judge cannot violate privileged communication if the profession is recognized under the law. That's also from Remley and Herlihy 2020. There are limits to confidentiality, which include knowledge of abuse or neglect of a child, an elderly person, or a person with disabilities, a person with suicidal ideation or plans to harm someone else, or a court-ordered subpoena for that client. I'll talk about two different limitations of confidentiality from Herlihy and Corey 2015. Limitation B2A deals with foreseeable harm and legal requirements. Confidentiality does not apply when a counselor is acting to protect the client or others from serious foreseeable harm. This also applies to legal demands of revealing confidential information. As a counselor, we should consult with other professionals in our decision-making process when it comes to breaking confidentiality. I would explain this to a client by saying that if a report occurs of abuse or neglect of a child, an elderly person, or a person with developmental disabilities, it will limit confidentiality. This includes self-harm or intent to others. I have an obligation to protect the client and those around them from harm. Limitation B2D considers court-ordered disclosure without client permission. In this case, the counselor is to try and get informed consent in writing from the client, try and prohibit the disclosure any way he or she can, or have the information narrowly limited due to the harm the release of information may cause the client or the therapeutic relationship. I would explain this to a client by saying that if a court-ordered subpoena were to be involved, my role is to advocate for the client's best interests and the best interest of society, not to go against the wishes of the client unless a crime has or is being committed. It's important to recognize that different states differ regarding confidentiality and privileged communication laws. According to a study by Kenny and colleagues, 2018, a review of state laws found that only 44 states mandate counselors to report child maltreatment. In Ohio, I found that there's many reasonable laws concerning breaking confidentiality in privileged communications, and this includes licensed professional clinical counselors, social workers, independent social workers, marriage and family therapists, or independent marriage and family therapists. This comes from section 2317.02 from codes.ohio.gov. First one is indication of clear and present danger concerning the client or others. The second one is the client consents to the testimony. Third, if there's a civil suit requiring testimony and the client was court ordered to treatment. Number 4, in a school setting, if a camera is shown in court and it's ruled that the camera depicts that the testimony of a school counselor is relevant to that action of the court. The fifth one is if the client testifies voluntarily, then a counselor is allowed to testify on the same subject. And lastly, if deceased, the spouse or executor of the state would give consent to break that confidentiality. So that's a little on Ohio laws. Thank you very much.